Ladies and gentlemen, welcome to today's webinar. Today's seminar presentation is Protecting Senior Citizens from Financial Exploitation Scams, Prevention and Remedies. Our presenter today is attorney Teresa Phillips. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. And similarly, if you have a question, you can type it into the questions section of the webinar interface. And now let me turn it over to our presenter. Go ahead, Teresa.
Hi, good afternoon, Tony. I hope everything's set up and everybody can see me. Welcome to our presentation today, protecting senior citizens from financial exploitation scams, and we're looking at preventions and remedies. And you'll notice on the slide there, I put part 1. When we started putting this together, we were hoping to put it all in one seminar, but honestly, there's so much out there, and it's such a current topic right now in Florida with our elderly population that we've decided to divide it up. So today we're going to focus on some remedies that maybe aren't the most obvious remedies that senior citizens and other vulnerable adults in our communities have, and get a good understanding of those. And then we're going to move on in the next couple of parts, which we're going to try to hold next month in August. We're going to look more specifically at what do elderly folks do when they're exploited by people like their banks or their financial advisors and things like that. And then we're going to try to focus one of these seminars on what we commonly called scams. We live in a world of a lot of new kind of scams going on today, with the world of of digital information and the way we live our lives. And they're finding that senior citizens are a big target of those scams for a number of reasons, and I'd like to focus some time on that as well. But today, let's delve in and try to get a good overview of what Florida has structured in an attempt to try to protect and give remedies. And maybe when we wrap this up at part 3, we can circle back around and see, in light of everything that's happening today, are these laws enough? And maybe ask ourselves those things and talk about some practical solutions that maybe you can employ in addition to relying upon what the law provides. So with that, let's get started. Let's get, just like we always like to start, let's look at our overall agenda today. We're going to divide this up in 5 areas. We're first going to take a look at what is exploitation. Let's look at the definition and the types of exploitation that are recognized under Florida law. Just briefly, there's different types of exploitation. It's not just for elderly. We have lots of vulnerable members of our community, such as children and things of that sort. And a lot of these laws overlap or apply to all those kind of categories, but we're going to focus our seminar on elderly and senior citizens and what's out there to protect them. Then we're going to look specifically at the types of financial exploitation, which is a big target for senior citizens. And then we're going to look at injunctions in order of protection. That's an area of law that a lot of my clients aren't aware of, that they have special rules and statutes that are designed to protect elderly folks that are being exploited by persons, and can sometimes be the quickest way to get a remedy. Then there's other remedies, and there's other ways to protect, such as criminal penalties. A lot of these activities constitute crimes. And then there's other remedies, such as civil remedies, where you can seek damages and other things as well. And then we're going to, as we always like to do, conclude with summarizing. I want to touch on a little bit of some of the most recent scams that have been warned out of the state attorney's office and other community programs that look out for the elderly. And then I'll take your questions. So let's move along so we can get to those questions. Okay, I want to start off just giving you some statistics, which are mostly troubling, to be honest. Approximately 1 in 10 Americans aged 60 plus have experienced some form of elder abuse. Some estimates range as high as 5 million elders who are abused each year. One study estimated that only 1 in 14 cases of abuse are reported to authorities. Financial abuse in Florida, which is what we're mostly focusing on today. In recent years, it's been revealed a dramatic increase in these overall percentages as it relates to financial abuse in Florida. A recent report suggests that the general percentage among all the different kinds of abuse, neglect, physical, financial, emotional, sexual, and all other types, financial makes up 12% of the national average of cases. When you think about the high population we have in Florida, you can see why this is a hot topic here in Florida. So that's why we're spending a day, or actually 3 parts, in our seminar looking at these issues. So what is exploitation? Florida law aims to protect against exploitation abuse against the elderly, disabled, and other vulnerable adults. There are laws found under Adult Protective Services, incapacity and guardianship statutes, and there's specific Florida state and abuse and exploitation statutes as well. Now, if you've joined me for any of my other seminars, you know I have focused a lot on guardianship lately and some of the potential abuses there. We're not going to deal with the incapacity and guardianship much today in this seminar. That's sort of a separate issue, and I don't want incapacity to be confused with what we're speaking of today. You can be elderly, you can be disabled, you can be vulnerable, but not necessarily that doesn't equal incapacity. Incapacity is when someone has reached a level where they can't make legal decisions, they can't make financial or personal decisions about their care. So that's a whole different category, and there's a whole set of protections for that. Now, sometimes it does overlap with what we're going to discuss today, but I'm focusing these seminars that we're talking about on those people that go about their everyday lives, can take care of themselves, but they're vulnerable or they're subject to exploitation because of their status as elderly. Exploitation focuses on persons exploiting the elderly or disabled financially or otherwise taking advantage of a position of confidence or trust. And I think that's probably the best synonym you can use is taking advantage of whatever position of confidence or trust. The biggest area that I see personally as a practitioner in these areas is when people that have been imposed with a position of confidence or trust take advantage of that. As we get older, and luckily we live in an age where a lot of services are available to our elderly to make their lives easier, to help them take care of their daily activities, even when maybe they're physically infirmed or you know, lacking the resources to do a lot of those things themselves. And those are good things, but those people also have an opportunity to take advantage. And it's not the norm, but it does happen. Now, abuse is a little different. It obviously focuses on physical abuse or neglect of a person, things of that. Again, most of these statutes deal with both, but we're going to focus on exploitation today. Okay, let's go through some definitions so you'll understand when I use these terms. A disabled adult is any person over 18 years of age who suffers from a condition of physical or mental incapacitation due to developmental disability, organic brain damage, or mental illness, or who has one or more physical or mental limitations that restricts the person's ability to perform the normal activities of daily living. Again, you can be elderly, but that doesn't necessarily mean you're disabled, and vice versa. Now, elderly person under Florida statute, and as we use the term today in the laws that we're going to go over, it means a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain damage or other physical, mental, or emotional dysfunctioning to the extent that the ability of the person to provide adequately for the person's own care or protection is impaired. That's much lesser than the standard for incapacity. Simply, that just means that if you're experiencing the normal effects that come with aging, of losing some memory, of being easily confused, not being able to just take care of some of your daily activities because you know, working the keyboards of a computer and things like that are a little too imposing. Those simple things can bring you under the definition of an elderly person if you meet the age requirement. Vulnerable adult is a more broad term we use. By definition, usually elderly persons and disabled people are brought under this definition of vulnerable adult, but it means any person 18 years of age or older whose ability to perform the normal activities of daily living or to provide for his or her own care or protection is impaired due to a mental, emotionally, sensory, long-term physical or development disability or dysfunction, or brain damage, or the infirmities of aging. The infirmities of aging in and of itself can make you vulnerable. Let's look at a few more. You're going to see me, I've already referenced position of trust and confidence, and I think I gave you a broad example. The caregiver is the go-to example. Caregivers who come into your home are given access to your possessions, maybe your financial records, maybe they help you pay your bills, maybe you give them cash or access to a credit card to go buy your groceries. They're given time with you. You come to rely upon them. That's your classic obtaining a position of trust and confidence. But the laws come up with a definition as we use it for the exploitation statutes, and here's what it is. With respect to an elderly person or a disabled adult, it means the position of a person who A, is a parent, spouse, adult child, or other relative by blood or marriage of the elderly person or disabled adult. Yes, our loved ones, our closest loved ones, have a position of trust and confidence. It's presumed by law that most of us trust them and give them, we don't treat them as third parties. We give them a level of trust and confidence, and simply by being a relative. B, another example under the definition. It's a joint tenant or tenant in common with the elderly person or disabled adult. The way the word joint tenant or tenant in common is used here, it means you share some kind of you share common interest in some kind of property. That can be bank accounts or real property or income producing property. For a common example, you put your nephew on your bank account because it's easier for him to go, because he picks up groceries for you, he picks up your medicines, and it's easier for him just to be able to use your debit card and things like that. That's a common example of someone that you may be given a position of trust and confidence, and it's recognized here under the law. C, a person who has a legal or fiduciary relationship with the elderly person or disabled adult, including but not limited to a court-appointed or voluntary guardian, trustee, attorney, or conservator. Again, we've talked about guardians in separate seminars. That's a specific kind of person that's put in charge by a court to look out after an incapacitated person. But we also have other things that are recognized under the law. One of the most common ones are trustees. When we set up trust, we give a person, a third party, power to control and make decisions, but they have a duty, a fiduciary duty because of that. Your attorneys, your professional advisors have the same thing. Conservator is a sort of a guardianship or trustee when they have they're supposed to take care of your property or a portion thereof. Number D, this is an example we already used before, a caregiver of the elderly person or disabled adult. E, any person who has been entrusted with or has assumed responsibility for the use or management of the elderly person's funds, assets, or property. So if you've been asking, maybe your neighbor wouldn't normally fall under the definitions before, but you've asked them to keep taking on maybe some responsibility, and they've been happy to do that, and they've assumed the responsibility of looking over your checking account and balancing your checkbook, maybe giving you some advice on moving monies around, things like that. They're going to fall under this definition of holding a position of trust and confidence. And with all these, I try to cite the statute at the bottom so you have that for reference. So let's look at types of financial exploitation. Now we're into part 2. Exploitation by financial helpers. There's basically 5 of these, of the types of financial exploitation that the statute provides for, and is going to give you some relief to try to have remedies if you are a victim of financial exploitation. And there's 5 general categories, and I've given them like helpful little titles here. The first one, I call it exploitation by quote unquote financial helpers. And the legal definitions underneath is when you knowingly obtaining or using or endeavoring to obtain or use an elderly person or disabled adult's funds, assets, or property with the intent to temporarily or permanently deprive the elderly person or disabled adult of the use, benefit, or possession of the funds, asset, or property, or to benefit someone other than the elderly person or disabled adult by a person who, 1, stands in a position of trust and confidence, or 2, has a business relationship with the elderly person. So again, if you're already fit in one of those positions of trust and confidence that we looked at, remember that can be a close relative, or you have a business relationship, and then you knowingly obtain, use, or endeavor to use that person's property to deprive them for your own benefit or a benefit of anyone other than the elderly person. You have that constitute financial exploitation under the statute. And this is usually people who come under the guise of helping, and that's why I call it your financial helpers. Number 2, exploitation of persons who lack capacity to consent. Okay, obtaining or using, endeavoring to obtain or use, or conspiring with another to obtain or use an elderly person's or disabled adult's funds, assets, or property with the intent to temporarily or permanently deprive the elderly person or disabled adult of the use, benefit, or possession of those funds, assets, or property, or to benefit someone other than the elderly person or disabled adult by a person who knows or reasonably should know that the elderly person or disabled adult lacks the capacity to consent. So here, the similar language, but the key here is that you have reason to know that this person does not understand and they lack the capacity to consent. That can be a whole host of scenarios you can probably imagine right now. That can be someone as simply as someone coming over, knocking on the door, trying to sell them a contract or some kind of complicated annuity, and being aware that they don't understand, maybe seeing signs that there's a guardianship or that there's, looking around the place that there's reason to believe that this person is not understanding what's going on, but allows them to sign off and do things anyway. Number 3, I call this exploitation by those who owe a duty to the person. And this is a breach of fiduciary duty to an elderly person. And the people who owe fiduciary duties are people like guardians, trustees, agents under a power of attorney. All of those, anything where they breach it and it results in an unauthorized appropriation, sale, or transfer of property. An unauthorized appropriation under this paragraph occurs when the elderly person or disabled adult does not receive the reasonably equivalent financial value in goods or services, or when the fiduciary violates any of these duties. And let's look at that. They commit fraud in obtaining their appointments, they abuse their powers, they waste, embezzle, or intentionally mismanage the assets, or they act contrary to the principal's sole benefit or best interest. This comes up a lot with people with who have powers of attorney. I have had banks call me or other financial institutions call and say someone came in with a power of attorney and said we have to do everything they say, and I'm quick to tell them no, they don't have unlimited, unfettered power. If they're acting contrary to the benefit, if they're embezzling, wasting, that exceeds their power, and they're committing financial exploitation actually. And some people seem to think that gives them some kind of shield to do anything they want. They can essentially exploit, abuse the person that gave them that, imposed that duty on them and gave them that position of trust. And in fact, they're committing financial exploitation as set forth in the statute. Some more examples for this breach of fiduciary duty. If you have guardians and trustees who commit fraud, abuse their power, waste, embezzle, or intentionally mismanage the assets. So, and now let's get back, and now let's go back to our general categories now that we've got out of breach of fiduciary duty. Now we're misusing access to an account. This is a common example because elderly persons and like a lot of other people, they give people access to an account for convenience sake, and then people take advantage of it. So the statute defines it as misappropriating, misusing, or transferring without authorization money belonging to an elderly person or disabled adult from an account in which the elderly person or disabled adult placed the funds, owned the funds, and was the sole contributor or payee of the funds before the misappropriation, misused, or unauthorized transfer. It applies to only these types of accounts: personal accounts, joint accounts, and that's even those created with the intent that only the elderly person or disabled adult enjoy the rights and interests thereto. Convenience accounts that are a special subcategory that you can create. All of those are common ways that elderly people try to make their lives a little easier. Common example is giving like I've already said, the nephew or the caregiver, put them on the account so they have their own debit card so they can buy the groceries, pick up whatever you need. But that's the intent. And even in not understanding that when you make them a sole owner, technically they can go into the bank account and they can withdraw whatever funds. But when they do that, in violation of the statute, they've committed financial exploitation. The fifth category of financial exploitation is specifically attributed to caregivers. It's intentionally or negligently failing to effectively use an elderly person's or disabled adult's income and assets for the necessities required for that person's support and maintenance by a caregiver or a person who stands in a position of trust and confidence with the elderly person or disabled adult. This is when the person gives you money and you, instead of spending it on something for them, you spend it for your benefit and you don't get them what they need and you don't use the income and assets for the necessities that require them. This is when the worst case scenario is when someone comes in to investigate and there's been a caregiver there for weeks and the person has no food, their bills haven't been paid, their home is in disarray, but the caregiver has a new car they bought themselves, saying they needed that to, transport them to the doctor's appointments and things like that. That's financial exploitation. So, what are one of the quickest ways you find out your elderly uncle or your mother, someone has been exploited? They have someone who's been coming into their home who they thought they could trust, and now they found out that they've been, garnering access to accounts, misusing them. They've been scaring the person, telling them that they need them and that they're gonna, and that they're gonna be harmed if they're not around. Things like that. They've gained their trust, and now the elderly person feels like they're in danger, or you feel like have a reasonable belief to believe they're in imminent danger of being exploited further. If this person is allowed contact, there is a special provisions that allow for you to seek an order of protection, essentially an injunction. You may have heard that in the context of domestic abuse, but there's also that for financial or other elderly exploitation. So who may file such a petition? A vulnerable adult who's in imminent danger of being exploited. Because the vulnerable adult doesn't always recognize that they're in danger, or too afraid to perhaps protect themselves, they allow other people to file, including a guardian, a person or organization acting with the consent of the vulnerable adult or his or her guardian, a person who simultaneously files a petition for determination of incapacity and appointment of an emergency temporary guardian with respect to the vulnerable adult. No, there's no minimum Florida residency required before you file. If you're residing in the county, even if it's just for a day, you can file. And it's just wherever the vulnerable adult resides at that time. You also know, I believe, there's no fee required at the time that you file, that this is a state expense. So what does it need to contain? And I'm giving you a summary of what it needs to contain here. What you would expect: a physical description, age, address, employment history of the victim, identification of the exploiter. They call them the respondent in these petitions. You need to be able to identify them by name, contact information, description, that kind of thing. Then you have to describe the relationship between the victim and the exploiter, including any explanation of any ways in which the victim depends upon that person for care, a summary of any reports that you've made to governmental agencies regarding the matter, including police reports, and a summary of the victim's assets, that's so that the court can fashion a result that will protect the victim. Note that it must be sworn, and meaning that you swear under oath that it's true and correct to the best of your knowledge, and you must allege the existence of exploitation or the imminent exploitation of a vulnerable adult. There's special rules if you have incapacity or guardianship proceedings that you'd have to look at, but these work ideally when someone just needs, they're not incapacitated, they don't really need guardianship, but they need some protection from a person to get them out of their lives or get them off their bank accounts or get them out of their homes. And a lot of times they've given these people, they've given them as part of their caregiving duties, they've given them access to their home, they can live there, and they're not going to leave without without a formal eviction or those kind of matters, or it's a family member that lives there, or maybe even has the right to live there because they're a co-owner and things like that. So these orders of protection can be fashioned to protect in those cases. This is the important language that must be contained in the petition above the signature line, and essentially you're acknowledging that you have reasonable cause to suspect that a vulnerable adult has been or is about to be abused, neglected, or exploited. It also makes you understand that you may be punished under penalties of perjury if you file false reports or something that's untrue. Then I've set here an example of what a petition looks like. If anybody would like a Word copy of this, I'll have my contact information at the end, and you can and I can send you a Word copy. But this is what most circuits in the state of Florida will accept as a good form. Again, you don't need an attorney, don't necessarily need an attorney. You know, I'm always in the business of advising that attorneys are good to have in any kind of legal matter, but it's not a require. And as I note here, the clerk of court is required to provide sample forms if you request them and reasonably assist a petitioner, and there's no fee. So what relief can be granted? You go in, you get your petition ready, you file it. Like any other injunction, there can be temporary relief if there's imminent danger and that there's not enough time to serve the other side. But generally speaking, whether it's temporary relief or permanent relief, these are the kind of things that you can ask for. Freeze the assets, accounts, or credit lines of the victim, including if they're jointly held with the other person. A very sad case I've been involved with, a son came from out of town for a visit and ended up drawing out lots of lines of credit with the father, you know, borrowers, but obviously it was the father's property that was the security and was the one likely to you know, to lose out if it wasn't paid. And even though they both were borrowers, technically the court had no problem freezing and telling the bank they can't let any more money out on that line of credit. And that's a way that you can really put elderly folks in a bad position. Usually people in that position in their lives, they don't need to be taking on more debt. Number two, enjoining others from having contact or taking exploitive action. This can be important. You have to remember in some of these situations, the elderly person or the vulnerable person has become dependent on the person. They're convinced they need them, where there's a caregiver, relative, whomever. And if you allow contact, they can scare them. They can invoke a fear reaction. And so sometimes you have to just say no contact to get them out of the clutches. 3, awarding exclusive possession rights of property in favor of the victim. This is where we talked about earlier, where they might have a right to possession or have an ownership interest in the property where the victim lives. They can make directives to law enforcement agencies to investigate to protect the vulnerable adult. They can do any other relief the court deems necessary for the protection of the vulnerable adult and or his assets. Freezing accounts, maybe not going so far to freeze, but limit the kind of withdrawals or action that can be taken on an account. And they can maybe order a different kind of caregiver or someone else to stand in and meet the needs that maybe aren't being met because someone's being enjoined from having contact. If there's an immediate and present danger of exploitation of the vulnerable adult, get temporary ex parte relief. It's just like any other injunction. If you can show that they're in danger of losing property or being in danger to themselves or their person, and that you don't have time to get the other side, served in 20 days to answer, you can go in. If you can prove those, you can swear it up on a petition and convince the judge you can get temporary ex parte relief. Now, it won't last. It only lasts up until the point where you have a final hearing or some hearing after they're served. But if it's important enough, if it's going to be too late in 15, 20 days, do it. So what are the penalties? Are these orders of protection, are they worth the effort? Well, the penalties can be pretty significant. Violations of an injunction for protection against an exploitation of a vulnerable adult. A willful violation constitutes a misdemeanor of the first degree and can become a third degree felony upon third conviction. Additionally, I would tell you, even though that might not sound terrible to have a misdemeanor on your record, when you have a record, any kind of conviction, a record of exploiting elderly or a vulnerable adult, that can keep you from getting a job, or keep that person from getting a job, being a caregiver, or being put in a position of trust. It can keep you from becoming a guardian or other things later on. So it has long-term effects that are designed to protect people from the people that tend to abuse or take advantage of positions. So what can victims do if the injunctions are violated? Okay, so you have this order of protection. It's not supposed to be at the house, not supposed to be accessing the accounts, things like that. If for some reason the bank's not freezing it, first thing you should do is contact the police. An injunction is an order, and violating it is a violation of law. So contact the police. If you're not getting if that's not satisfactory, or it's not fast enough, or if for whatever reason the police have declined not to investigate, with the assistance of the clerk of court, you can prepare and file an affidavit of violation. So the court can initiate an investigation by local authorities in the state attorney's office. You file an affidavit, just, swearing to what has happened. He showed up at my house this day, or he called me on this date, and the court can initiate and cause local authorities to investigate. 3, the court can make a ruling to hold the respondent in criminal contempt, and that can come along with fines, jail time, and other penalties. And you can get an award of damages for injuries sustained due to the violation. If you had to leave your home and go stay in a hotel or some secure area or other things like that, you can be awarded the damages because of the violation and what it caused. What are some other criminal penalties and remedies for these kind of actions? Well, Section 825.103 Florida statute provides criminal penalties for exploitation. This is not related to the injunction. This is if you're found guilty of exploitation of an elderly person or disabled adult. It's a felony, first degree, if the property value involves $50,000 or more. It's a felony of the second degree if property involves $10,000 but less than $50,000. And it's a felony of the third degree if the property value involved is less than $10,000. So in any case, you're looking at a felony, which is a serious crime, and certainly something serious to have on your record. There's a presumption of exploitation in certain cases, and it's important to be aware of this, both in when you're trying to protect elderly persons, or if you're dealing with elderly persons. As advisors, sometimes we have elderly clients who come in and they maybe have people we don't know, who seem to be non-relatives. We've had a relationship with this client, they're new, and it's important to know about this, I think, from that perspective as well. There's a presumption of exploitation when there's exploitative transfers of property or money in excess of $10,000 in value, whether that's single or multiple transactions, by a person who's at least 65 years of age, and those transfers are to a non-relative whom the transferor knew for fewer than 2 years before the first transfer, and for which fair value is not exchanged. That's a presumption. So if someone gives $10,000 worth of gifts, who's over 65 years of age, to a non-relative that they haven't known very long, and there can be some presumptions of exploitation here. Now, the presumption does not apply if a valid loan evidenced in writing that includes definitive repayment terms is present, and that loan does not fall into default for more than 65 days. It doesn't apply to persons who are in the business of making loans, and it's not applied if it's a bona fide charitable donation to nonprofit organizations that qualify for tax-exempt status under the IRS. If you've practiced long enough, one day you're probably going to get a call. Hey, my dad, or my mom was contacted by someone. They thought they were their friend. They gave them some money. They thought they were going to do something for them, and they never showed back up. In most cases, that's, buyer beware kind of things. If someone, comes by and says they're going to do some help for me and I give them money, a lot of that's not going to have special rules that apply. But in the case of elderly folks, they may have committed exploitation here, and you're going to get the benefit of the presumption no matter what the exchange was, no matter what the intent was. You've already got a presumption here. So when they think they can't do anything about it, when they realize they think may have been taken advantage of, that's not accurate. There's a presumption of exploitation, and there might be criminal penalties. So let's look at criminal penalties related to reporting. As with anything, reporting can require an obligation and duty, and it can also carry with it people who make false reports. And there's some statutes you should be aware of. A person who knowingly and willfully fails to report a cause of known or suspected abuse, neglect, or exploitation of a vulnerable adult, or who knowingly and willfully prevents another person from doing so, commits a misdemeanor of the second degree. A person who knowingly and willfully makes filing a false report to APS, that's Adult Protective Services, or law enforcement agencies, or advises another to do the same, commits a felony of the third degree. So, obviously the key words there are knowingly and willfully. You may have seen, something that's unknown, but you may not know, and you may be failing to report, not because you're trying to willfully violate, but because you're not sure, or because of the dynamics of the situation. But the knowingly and willfully making a false report, can, because you want to cause trouble for someone, or because you're jealous of your brother who stays over there a lot, those kind of things will get you in trouble. Making a report because someone told you, or because you came across the person and things look very suspicious and then didn't prove out, that's probably not going to be knowingly and willfully making a filing or false report. Civil remedies. Yes, there's a cause of action under section 415.1111. A vulnerable adult may recover actual and punitive damages for abuse, neglect, or exploitation. Actual and punitive. They can recover their reasonable attorney's fees. Actually, the prevailing parties may be awarded those, and it's a discretionary may. The action may be brought by the vulnerable adult or that person's guardian, by a person or organization acting on behalf of the vulnerable adult with the consent of that person or that person's guardian, or by the personal representative of the estate of a deceased victim, without regard to whether the cause of death resulted from the abuse, neglect, or exploitation. So, in the late days of someone's life, this happens and people show up, they convince them to give them access to credit cards, write them a check, and then they die maybe a few days later, a few weeks later. The personal representative should look at and be very suspicious of those transactions because they may have a cause of action to go after that person for actual and punitive damages. Finally, you need a report. Reporting is probably one of the most important things you can do in these situations. Report, giving you some information up there. I also want you to be aware that there's the state attorney's office website that also gives information and goes beyond just abuse or exploitation, but it also gives you some common things to look at. It gives you some common things to try to avoid. Some of the things they always tell elderly folks and vulnerable folks to be aware of. Anytime you're feeling pressure to do something, that's an indicia of perhaps you're being exploited. When there's a time crunch, there's intense pressure for you to do something, even when you show reluctance or a lack of understanding, that should be suspect. Be suspect of people who want you to sign things and they don't want you to read them, or you don't have a chance to read them or look them over with other people. Also be suspicious if anyone's trying to isolate you from other folks, from family members, friends, or what have you. And if all of a sudden, they're screening your calls and they're telling you shouldn't be talking to people or this person, that's always a red flag. Be aware of people who call you that you don't know. Always be suspicious on things like that. And that probably falls more under the definition of scams, which we'll get to, but and this more falls under people that we know, people who oftentimes have a position of trust and confidence, who are relatives, who are friends, who take care of daily, your daily activities, and who you think of as a companion and maybe even a friend. But there's a wide range of things that can be directed toward the elderly, more vulnerable portions of our population. And part of the seminar is to make you more aware of that, make you aware of some of the remedies and penalties and things like we've discussed today, but be more aware as a person, as someone maybe who advises those persons of red flags and things like that, and try to avoid them. That's my contact information. I want to spend the last few minutes here kind of giving you a lead into what we'll be talking about later on. I oftentimes get calls about, has my bank exploited me? Do I have an action against my bank? Does my bank take any action to protect me if I'm being exploited? That's one of the things I want to get into. And in our next seminar, what about the professionals in your life? What do you do when the person that might be exploiting you or taking advantage of you or your client is a bank, a financial advisor, an attorney, a doctor, or other professional, someone who holds that kind of position? Do they have what are their obligations under the law, and what are your remedies under the law? We're going to look more at those specific categories. And then eventually we're also going to look more at scams. And I'm making an effort, and our firm's making an effort of making more awareness go out. Part of looking at the next week too, we're going to look at things that you can do to try to prevent these activities. Much like in my guardianship seminars, it's always the same recommendations. plan ahead to try to avoid these situations. Have good conversations with your loved ones, your most trusted advisors. Get good planning in place. Have good protections over your assets. Trusts, people you trust as co-account holders, people who may see your accounts and may be able to determine that there's red flags or see things that are unusual. Having those people in place, having some protections in place, it's not a sign of weakness. It's actually a sign of good planning, and it can prevent a lot of these things. Be very careful on who you give your power of attorney to. Do not make that, do not feel obligated to make certain people your attorney. In fact, I get that a lot where people come in and say, well, I have to make my kids, or I have to make this person. No, you don't. And you shouldn't if you have any questions about what might happen. I want to make they're taking care of me, they're helping me. I want to make their life easier, is something I hear a lot of times. So I'm going to put them on all my property and on all my accounts, and I trust them not to do anything like that. Just because someone's helping you, whether it's gratuitously or whether they're getting paid to it, you don't have to reward them with access to property and things like that. If anything, I always say turn it around and say you don't want to put them in that kind of a position where it gives an appearance of impropriety or anything like that. You want to protect them too. And I'm gonna end today with one of some of the most common scams that are going on. One of which is I've been reading about jury scams. With COVID-19, most juries have been suspended. Most jury trials have been suspended in Florida. All of them, actually. They just started doing some pilot programs. So those of us who, at least like I'm one of the lucky ones, it seems like I get a summons every year, every other year at least. You may have gotten summons that just got automatically generated, and then you were probably told don't worry about it and things like that. Well, people have found out if they've called, especially elderly people who get very concerned if they've not met their obligation under jury duty summons, and they say you've missed, and they insist that you missed. They come to your door, represent themselves as law enforcement or judicial officers, and they demand a fee or a fine to fix the situation. And what they're doing, they're taking advantage of the confusion that COVID-19 has caused. Do not fall for these scams. Call your local clerk of court. Call the local police department. Call your lawyer. Call people you trust. That's not how people handle. Even if you were not showing up to jury duty, that's not how they handle it. You don't send police officers to collect fines. Additionally, you should just know that there have been no jury trials up until recently. Some of the counties, about 5 counties, are starting a pilot program, and Orange County is going to be one of them where they're testing doing jury trials and protective measures, and all those are voluntary. And it's very easy to get out of the jury duty if you have any concerns about your safety or any concerns about your health and exposing yourself. Do not fall to these high pressure tactics that try to make you feel fearful or confused, because there's a little bit question what's going on now with COVID-19 with our judicial system. I invite you in the future to look back at our website as one of your resources. We're going to try to keep our people who come to that website informed of these things. Myself and our firm are dedicated to being part of the solution, getting out there informing people, making people aware of the scams, making people aware of the remedies they have, and some pre-planning things they can do as well. I hope you've enjoyed this first part of it. I hope it gives you a good idea of what we're going to be looking at in the future. And if you have any questions, again, there's my contact information. Please feel free to call me or email me at phillips@fbl-law.com. Thank you for your time.